Okay, let's look at criminal law definition. Continuing with your notes. Crime by definition is a social harm that is made punishable by law. Webster defines it as an offense against morality, or an act or an omission forbidden or prohibited by law that is not designated as a civil infraction. We know that there are laws that are civil infractions. So if it's not defined or designated to be a civil infraction, then it falls within the category of a crime. Maybe a misdemeanor, maybe a felony. So what does it mean to act? Obviously, we know when somebody does something, but an omission to act. Omission, again, Ivy, two new words that you're learning, is a failure to act. So under what cases would you fail to act and commit a crime? Child neglect would be one of those cases, or educational neglect. Not sending a child to school is an educational neglect that can result in punitive and criminal charges being brought against you. Let's look at the HIV and AIDS. Some years ago, the fact that an individual did not advise his intimate partners that he had AIDS or HIV, so there was a failure for him to let people know that he had previously been diagnosed with AIDS, and yet he engaged in specifically sexual penetration with another person when he in fact knew, or she knows, they have been diagnosed with HIV or AIDS. That would fall into the failing to act, failing to inform, and society has deemed that to be a 4-year felony. Felonies, as I stated, are punishable by one or more. Felonies can be punishable by the death penalty or death. However, again, I reiterate that Michigan does not have the death penalty. Felonies, though, result in imprisonment in a state prison for greater than 2 years. Greater than a year, actually, but typically a high circuit court misdemeanor may get you 2 years, and most state felonies are 4 years or more. It will get you a fine, and it may get you removed or dismissed from office. Such was the case when we're looking at Kwame. He faced several charges, and he was dismissed from office, I believe as a result of his ongoing investigation. Okay, so who can be charged with a crime? Pay attention, because who you hang out with might not be a good or wise choice. Okay, so who can be charged with a crime? Any party of the crime. In Michigan, anyone involved in the incident can be viewed as the principal actor, meaning if you are the one who knows a crime is going to happen and is an accessory before the crime, you help prepare for the crime, but you don't actually do it, you still, in Michigan, can be charged with that crime. If you're the one who helps clean up after the fact, you may have not committed the crime, but you were the accessory after the crime, and in fact could be, in Michigan, charged with the crime, whatever crime that might be. Okay, so Michigan will view people involved in any way as principal actors. Okay, again, when we look at the crime, you have to understand the elements. You've heard me use this in the past, and now we're going to have a better understanding of what I speak of when I say the elements. Elements are like pieces of the puzzle. They make up the entire puzzle so you can see the picture. And they have to be met. You need all the pieces in order for the crime, the correct crime, to be designated. All of the pieces together gives us our corpus delicti. Corpus or body of the crime. Okay? The specific points which make up that crime. There are specific elements that make a table, different than the elements that make a computer. So we need to figure out the elements of each crime. And each element must be proved before the defendant will in fact be incarcerated, but before the defendant can even be charged. If the prosecutor reviews your report and does not recognize that the individual whom you suggest or have listed as the suspect or perpetrator, if your report does not reflect the elements of the crime, then they will not charge the person that you had listed as the quote-unquote bad guy. Okay, so now when we're looking at the elements, it's not just merely the fact that somebody did something. If I take your coat, can you charge me with a crime? Will prosecution charge me with a crime, or the police come and arrest me? Well, we have to look at the facts. Why did I take your coat? How did I take your coat? Did I mean to take your coat? It didn't look like my coat, and I thought it was mine, so that's why I took it? If so, did I commit a crime? Well, we have to view what is required to have a crime be considered a crime. It's not merely just the act. If I walk into your house and I thought it was my friends who invited me over, did I commit a crime? Or was it merely an accident? So let's take a look at what is required. Latin words you will need to know. We have corpus delicti. That's your first one. That's the body. But now let's take a look at actus reus. I may not be saying it absolutely correct, but in essence, it's the guilty act. Actus, that word is right in there. You have to have culpable behavior. You need to understand what you're doing is not right and on purpose. I take your coat. I'm not culpable. I did it by accident. It looked like mine. I thought it was my friend's. I did not mean to purposefully deprive you of your coat. So that behavior, therefore, is not culpable. Okay. So beyond the act that you have, that has to be a guilty act, one's desire to deprive you of your coat, I also have to have the mens rea, the guilty mind. Did I intend to commit the crime? Did I understand right from wrong? So the act in and of itself, was it a guilty act, and was there a guilty mind? Okay. When we're looking at the actus reus and the mens rea, we need to look at the intent. There are specific and general intent crimes. Specific intent shows the perpetrator did the acts with the intent to cause a particular result, such as larceny. That would have to be a specific intent crime. It is meant that you permanently, your desire was to, or the perpetrator's desire was to permanently deprive the property owner of whatever property it is you took from them. The intent may be proven by what is said or did, or what others witnessed. It is any act and circumstances can be used as the evidence. So if we knew that you wanted to take the coat to specifically deprive me of it, then you could be charged with the larceny. There are general intent crimes as well. The intent to do an act which the law prohibits. Okay? Those do not have to have the capacity to commit a crime, such as infants or insane, lack the essential means. Who reviews and determines the charges? The prosecutor. So you can write it up, you can find that a coat is dismissed. Somebody can say that it was taken from the party or from school. But now you have to determine if there was a crime. And when you write up all the facts, the prosecutor will review it and determine if the corpus delicti, body of the crime, is presented in the report, and then move forward with determining the specific and direct charges that they will issue. Okay, time for a break.